Just calling the meeting to order. This meeting of the Board of Chiropractic Examiners Licensing Committee is being held by teleconference in accordance with the provisions of Government Code Section 11123.5. Committee members are participating virtually today from remote locations, and board staff is present at the following primary physical meeting location: Department of Consumer Affairs, the El Dorado Room, 1625 North Market Boulevard, Suite N220, Sacramento, California, 95834. The date is Friday, June 13th, 2025, and the time is 12:31. The board's paramount responsibility is to protect the health, welfare, and safety of the public through licensure, education, engagement, and enforcement in chiropractic care. Members of the public may address the committee during the public comment session. Public comments will also be taken on agenda items at the time the item is heard and prior to the committee taking any action on said items. Those who would like to provide public comment will be limited to 3 minutes, unless in the discretion of the committee, circumstances require a longer period. Members of the public will not be permitted to yield their allotted time to other members of the public to make comments. Individuals may appear before the committee to discuss items not on today's agenda. However, the committee may not discuss or take action on these items except to decide whether to place the matter on the agenda for a future meeting. Please be aware that this meeting is being recorded, and please turn off and silence all cell phones. We will now take roll. Ms. Cruz?
Dr. Daniels?
Present.
Ms. Cruz, present. We have a quorum.
Great. Thank you. We'll go ahead and move to agenda item number 2, which is public comment for items not on the agenda. Moderator, could you please open that up for public comment?
Sure. This is the moderator for members of the public on WebEx. If you would like to make a public comment for items not on the agenda, please click the raise hand icon. Or if you're an audio-only participant, you can raise your hand by pressing *3 on your device. All right, and I do have a request from Brian Ota. Brian, you will be given 3 minutes to speak and a 15-second warning. Please click the unmute me button when the prompt appears on your device.
Can you hear me?
Yes, we can hear you.
Great. Thanks for giving me my 3 minutes. I'm hoping to kind of revive a conversation that had started maybe 4 or 5 years ago. It involved the former executive director. I think Kristen Walker was also in this conversation, and Dr. Paris. And to summarize, it involves possibly either creating a different type of licensure or trying to figure out a way to categorize my team in a different type of licensure than we are currently. For context, because of some NDA things I'm not allowed to say, but I am allowed to say that I work on the campus of a large Mountain View-based search engine company. And we have multiple locations within the campuses, and there are times when our chiropractors need to work in an alternate location than the one that's listed on their satellite license. And then sometimes we don't have a whole bunch of notice because things happen quickly on campus here, and sometimes we're just not given a lot of notice, and then all of a sudden we're scrambling to get new satellite licenses and try to stay within compliance of with the board. So we had started this discussion years ago, like I said, and then it kind of dropped off. I believe I brought it up at the board one time and was told that I was going to get notified when we could talk about it again, and I just never heard anything. So I'm wondering if we could put this on a future agenda to talk about it. I don't know if there's other options that have happened in the last few years for this, or if even possibly using like a mobile chiropractic license would work for us to kind of cover us so that we pay the annual fee, but we're able to work anywhere within, say, a certain campus. Like most of our offices are concentrated in the Sunnyvale Mountain View area. So if we had a license that covered us within the Sunnyvale Mountain View area, and we could work anywhere within there. I don't know if you need any more information than that. Does that kind of cover the basics? Yeah.
Moderator, do you want to assist with the instructions?
Sure. This is the moderator. I believe for public comment, the committee is not to respond, but just to hear the public comment. So if you don't have anything else to say, we can move on.
Okay. Should I expect some sort of response? Like if this is going to be put on a future agenda?
So Brian, we got your comment and we will discuss putting it on the future agenda. We're not allowed to talk about it, but just we've actually had licensing has had multiple conversations regarding your concern. So it actually has been a current conversation. So just make sure you forward your contact information to the board, and then we'll discuss putting it on for a future agenda item.
Okay. I just wanted to know what next steps would be.
Thank you.
Thank you.
All right. This is the moderator. Appears there are no further requests for public comment at this time.
Okay, thank you. So agenda item number 3, we're actually going to postpone approval to the September 5th meeting so that the board members have ample time to see if they want to make sure to bring anything forward from those conversations. So we have them. They've been, cursorily reviewed, but we're going to move the approval to September 5th. Any comments? Okay. All right. Moving on to agenda item number 4. I'll give this to Ms. Walker. Update on board's licensing program.
Hi, good afternoon now, committee members. I just want to confirm everyone can hear me because we've got it set up here in the Eldorado room.
This is the moderator. You are a little quiet. Is it possible to get the microphone just a little bit closer to you?
Yeah.
Yeah. I'll speak up as well. I want to cover a few things as part of today's licensing program update. Most exciting of which is starting with personnel updates. So we had Amanda Oppo recently accepted our lead licensing and CE analyst position. She started in that role effective June 2nd. So we're really excited to get her involved in not only supporting this committee, but also the CE committee, and then working on a lot of the program aspects of both licensing and continuing education. Amanda brings about 5.5 years of experience at BCE in our continuing education and our enforcement units. So really excited to have her on board and supporting this committee going forward. 2 other personnel updates that I'm happy to share as well. We have a new employee, Shelly Anderson, who was hired as our licensing technician, and Monday is going to be her first day at BCE. And then we also recently selected Jose Diaz as our new administration and licensing manager. He's transferring to us from another state service role, so his first day with us is going to be on July 14th. So with that, that fills out our staffing actually for the licensing and CE programs. Really excited about that. Also wanted to highlight a few items that we've been tracking with respect to CCE. At their January meeting, CCE awarded the initial accreditation to Campbellsville University in Kentucky. So staff is going to be reaching out to them just to, one, congratulate them on their initial accreditation, but also start the conversations around them entering the approval process for board approval of their chiropractic program now that they have that accreditation. We also noted that Kaiser University out of Florida remains on probation with CCE due to a non-compliance issue with their licensing exam success rate. Kaiser's next report to CCE is due in December, so we're continuing to monitor that status. They currently have provisional approval under the board, so our plan is to engage with them a little bit further on the full board approval process after they resolve their CCE probation. Also, in line with licensing, I want to highlight a little bit around exam development and validation. If you recall, last fall, DCA's Office of Professional Examination Services completed their occupational analysis of the chiropractic profession in California and released their report. OPES has also been working on a validation report of the national exam, parts 1 through 4, and physiotherapy. And we're expecting that that final report is going to be released soon, likely in July. So with the release of both of those reports, we've worked with OPES and we have them on the agenda to present to the board at the August 1st meeting, where they can provide an overview of all the work that they do with reviewing national exams and then developing the state exam and the CCLE. And they can also discuss with the board some opportunities for more engagement directly with the board and how we can be a little bit more efficient with that process and developing the law exam. So we're looking forward to having them as guests at our next meeting. Let's see here. As far as legislation, there's not a lot of legislative activity going on as it relates to our licensing program. The most impactful bill that was introduced this year was SB 687 on animal chiropractic. And it's dead for 2025, and it'll be revisited in the spring, or actually in winter when the legislature resumes for 2026. The other bills that affect us have really minor effects. Most notably is and there's another bill on expediting or prioritizing certain applicants. Those are things to where we're in a good position with our board that we don't have a licensing backlog. I mean, as of this morning, our backlog, if you want to even call it that, but our pending applications for licensure is 22. So it's very small volume, and all of those applications are pending just because we don't have the documentation we need to move them to the next step. So when it comes to legislation, we're continuing to track, but we're not seeing anything all that impactful for our licensing program. Like I said, that animal chiropractic bill would have been very impactful, but it's still at the committee stage at this time and not moving forward this year. Also wanted to highlight just a few of our program statistics. Of note, we issued our first temporary DC license. So that program went into effect, I believe it was in 2023, that required that we begin issuing temporary DC licenses to military spouses. We've gotten one application. We received it last fiscal year, and then that applicant passed the CCLE and was recently issued that license. So we've got our first temporary DC license. We're continuing to see a pretty good volume of DC licenses and, of course, satellite certificates. And we've been really fine-tuning our processes as we're getting ready for bringing on a new manager and a new technician to try to, wherever possible, just eliminate any kind of backlogs or any kind of bumps in the path of getting those approvals forward. Happy to report that as of this spring and heading into summer, we've been able to really fine-tune that process to the level to somebody can get their initial license after they've passed the CCLE. If they're applying by that afternoon, they're very likely going to get their license that same day. And if not, they're going to get it the next business day. So significantly getting those processing times down for our DC licenses compared to years back when you were talking months to get a license. Right now, applicants are really in the driver's seat as far as how long it takes to get a license, because after we get all of their documentation, it's getting approved either that day, the next day, qualifying them for the CCLE. And then in turn, after they've passed and paid the initial license fee, we're doing the same thing and getting it done within a business day or so. We're trying to take that same kind of time frame and cut down on how long it's taking for us to issue satellite certificates. Right now, we're at about 10 days. Our initial goal was established at 14, so we're meeting that target. We're trying to cut that down even further and trying to get that into 1 to 3 business days as well. So a lot of work going on the licensing program side. And then also when it comes to business modernization, we've been doing a lot of work in that area. As of right now, we've continued to enhance and work on the Connect project. Happy to report that our latest statistics on it is we've got an adoption rate of about 90% for our brand new licensees. So almost all of our new applicants are applying through the Connect system, which is great. We're also now seeing about 50% of an adoption rate for our licensees. So we were closer to about 30% a year ago. So we've definitely made some improvements, and we're trying to get that number a little bit higher into 75% or so. We're also now testing some cashiering functionality that's going to streamline our paper renewal process. We're working on a method to where we can integrate paper applications fully into the Connect system so that if somebody started on paper, they could theoretically finish in Connect. So we're kind of testing what that workflow would end up looking like. And the most exciting thing that we have at the staff level coming as far as business modernization is new AI technology coming very soon. The department's going to be launching Microsoft Copilot and releasing that to all the programs. So we're beginning to have conversations at the staff level around how we can leverage that technology in our business processes, and then other potential cost-effective AI solutions that we could use as well. Also within the meeting materials is an update on our different regulations that we have. So we now have 2 of our regulations that are reaching the final filing phase, meaning they've gone through the public comment. We've reviewed and responded to them, and we have to get the final filing off to OAL. There's not currently any for the licensing program yet in the initial filing phase, but we have many on the way. And then we've just got a few more discussion items for that the committee's been working on. Most notably is the curriculum requirements. So we're working to get that text finalized, and we'd like to see the final product presented to the board for the August 1st meeting. We're also working with legal on some edits to the renewal and restoration of DC licenses and the basic life support certification text, and we're planning to bring that to the August 1st meeting as well. So that's a bit of what's been going on with licensing. Happy to answer any questions from the committee on the program update or anything else.
Thanks, that was great. There's a lot happening, which is awesome, and I'm so glad you have more staff. I had a question on AB 742. We don't really have a backlog. I'm just wondering if that passes, are there still going to be costs and hoops that we need to do and justify even though we don't have a backlog? Does that make sense?
It does. There's some very minimal costs that are entirely absorbable within our workload on the implementation that we are going to have to do. So we're going to have to make if it becomes effective, we're going to have to make some minor updates to our regulations on the initial licensure process, where if you recall at the April meeting, the board approved the text where it lays out all the conditions that you can get a license expedited. We would have to refine that language further and add the additional provisions. So it'd be a few $1,000s in staff time to make those edits, and then a few $1,000s in IT costs for us to modify the application. So yes, there are costs. They're rather minimal, but there are implementation costs associated with that bill.
And I know we asked before, I mean, did we ask for an exemption on this, or is that not a possibility?
We can ask for one. It's one of those where it's kind of, I was kind of watching to see how it was even going to progress as far as the bill. As it starts getting a little bit further into committee, we can have those discussions with the author's office. It's similar to the way I'm viewing it is it's very similar to what we have for the expedited of visa holders. So we have we'll get applications from them, and a lot of times the problem is when you are attempting for our board, when you attempt to expedite, you're actually slightly slowing them down because we don't, like you're aware, we don't have a backlog.
Well, that's what I'm kind of concerned with, that
yeah,
it will slow it down versus leaving it as is, and so it sort of defeats the purpose.
Right. Yeah. So what staff's doing is just, if we have the information to move it forward, we're processing it as is. We're putting the note and letting the applicant know that that portion of it was deficient. However, we have what we need to get you qualified for the CCLE, and we're going to move your application forward. But yeah, I think definitely we'll have those conversations with the author's office over the summer, because it's just unlike there are other DCA programs with months-long backlogs in licensing. We're fortunate to not be that program.
Yeah. Okay. Thank you. And then thanks for going over and highlighting the phases of where we're at. I just wanted, are we on track? I know you said summer for the inactive license, is that on track for getting that moving forward?
Yes, yes. With all of the different regulation packages that we have, we've got a rather large chunk at the staff level that need to get moved into that initial filing phase.
Okay.
And we're really aggressively looking at those timelines because we want to get all of these pending regulations moving into that phase and into final heading into sunset. So it's kind of going to be a pretty high volume dropping in late summer into the fall, so that we've kind of wrapped up all of the work that we've been doing over the last, basically call it the sunset review period. And then we can focus on the what's next as we head into our sunset hearing.
Okay. And then have we made any progress on getting a survey for the retired license issue?
Not yet. That's on our list, and I'm actually going to be working with Amanda to get that going.
Okay, great. And then for me, just one last question. It was great to hear the adoption of the Connect system. And you said the licensees have gone from like 30 to 50% in the last year. Is that without like notification, advertisement?
It's with the that jump in change had to do with us changing the packet itself that's going out to licensees, where we fix the wording and put more of an emphasis on going online. We still do need to have a broader campaign to really encourage the use of the system, and that's another fun project that I'm tasking Amanda with.
Okay, great. Because I was like, I didn't get a notice on that. Okay, awesome. Ms. Cruz, do you have any questions?
Yes, let me go back to my tab here. So going to the Connect system, it's like I saw that some things are on just upgrading to the next version of Connect is on pause due to vendor kind of accessing kind of vendor availability. Any concerns, and this is just me kind of understanding risk. Are we in a situation where we're up against no longer being able to be supported, the technology being supported, or is it just, or are we still in a good space in terms of moving to the next version and still being supported under the version we're on?
We're still safe in being supported on the version
Okay.
that we're on. What the next version unlocks for us is more of the ability, because the challenge with the version of the software we're on right now is it doesn't work very well under scenarios like a corporation license, or eventually when we get to working at the facility level where it links one certificate type to multiple users. That's what the next version does better. And then the next version also gives you a little bit more control over updating your form fields and things, to where we don't have to go through the vendor. We can actually use the department's own IT resources to update forms as necessary. So it gives us more flexibility, and it unlocks the future, but we are still supported on the current version.
Okay, good. I wasn't sure if it was one of those end of life situations. Okay, so that's
No.
good. And then interested to know, we're going from 30% to 90%. What do you kind of think has gone differently?
So it's 30 to 50% for licensees. We're still trying to get them on there. The good news, so it's our new applicants are good early adopters, and they're getting on there at 90+ percent. And a lot of that is to the credit of the school. So when the schools are getting in and presenting to students on the licensure process, when our board members are going out and doing that engagement, we've been really encouraging the Connect system, because it's just so quick. We can we have approved people same day. Like they apply, they've already sent us their documentation. We can get them approved for the CCLE that same day if they go through that system. So we've been doing a lot of the outreach at that level. And I think also, knowing that a lot of those students are probably much more engaged when it comes to technology, they're naturally wanting to use it. But we're seeing a lot at that level, and we're seeing them continue to renew as they build towards licensure. It's just, we've got to still try to continue tackling our existing licensees and getting them also on the system.
Okay. And I think it's, for me, I think this is more of a comment on, I saw that the national practical exams are being centralized to Colorado. I did a quick Google search earlier, just understanding. I was like, well, if they're being centralized to one single location in the center of the country, it looks like we've had, at least California's been able to experience access to it in Hayward, California. And this isn't a question, but it's more of a comment of, I think, of general concern of accessibility of just folks being able to access the exam in the future. So more of just a comment. I wanted to put it out there of something I'm concerned about. I know it was just announced. I know it's kind of, there's going to be time before it happens, but something in the back of my head in terms of kind of ability to access, and especially of us trying to make sure that the profession itself is accessible. And that's
Yes,
it.
and that's a
Oh, go ahead.
I was
Sorry.
going to just briefly say that's a good comment. I actually was discussing that a bit with Dr. Adams yesterday
Mhm.
around that testing center, just because it's going to one central location. So
One.
there are those concerns. We're going to look into it a little further as far as what other states might be doing. He had mentioned that he was thinking that there's some other states that are looking at even potentially another alternative so that they
Mhm.
can increase that accessibility, because right
Mhm.
now Part 4 is on all the college campuses. So that's where it's
Yeah.
accessible. They are relocating to Greeley, Colorado, which is about an hour from a major airport. So that was the one concern. They're modernizing, but it's more difficult to try to get there. They've got some FAQs and some information up there around, how they make that happen. But definitely a concern, and we saw that as well.
Yeah, there's also chatter, and it kind of will fall into the reciprocity conversation about, and this perhaps is what you're alluding to, but of states potentially dropping um, national boards because of the move. So that's something that we need to be aware of and discuss, which we will we can bring that into the next agenda item. But there's a lot of um, sort of not so happy uh, opinions about it, and very strong opinions about it because of the one location difficult to get to and some other issues. So
Mhm. No more questions for me.
okay. Moderator, can you open up agenda item number 4 for public comment?
This is a moderator for members of the public on WebEx. If you would like to make a public comment on this item, you can click the raise hand icon, or if you're an audio only participant, you can raise your hand by pressing *3 on your device. All right, and it appears there are no requests for public comment at this time.
Okay, great. Thank you. Any more comments before we move on to agenda item number 5?
None for me.
Okay. Miss Amanda, can you introduce agenda item number 5 on licensing and reciprocity and endorsement?
And let me just move this microphone over to me now. Can you hear me okay?
Yeah, perfect.
Okay, great. So today we want the committee to discuss the potential pathway to Doctor of Chiropractic licensure by reciprocity or endorsement. The board identified reciprocity as an objective in our strategic plan and in our 2022 sunset review in order to attract more licensees to the state and remove potential barriers to licensure. In April, the board approved the new initial license application exam process. And now we're looking to define reciprocity as well. The current reciprocity requires the same level of documentation to be submitted as the initial license application. It really only provides an exemption for those who are missing parts of the NBCE exam because they were licensed before they existed. For example, someone who has been licensed in another state for decades would need to get their state's endorsement and still have their chiropractic college and NBCE submit transcripts directly to the board. And if they don't meet the board's curriculum requirements, they would need to re-enroll in a chiropractic college in order to then apply for licensure. So we would like the committee to discuss if you are willing to accept another state's endorsement in lieu of a primary source verification from the chiropractic college and NBCE, and if a certain number of years of practice can set off the potential or can offset the potential deficiencies in the quantitative requirements that we have, such as hours of subject areas, clinic hours, or the number of exams and tests I need to conduct.
Great, thank you. So I'll just throw a few things out there. We can just start with the question really of if I think we need to look at, oh, what's that?
Oh,
She was just moving the microphone. We're good.
Oh,
so Kristen
sorry.
can talk too. Sorry.
Okay, got it. So we sort of need to look at potentially if states drop the requirement for national boards, what is that going to look like? And if we drop the direct verification, one of my questions is who then is responsible? So as far as if there was misinformation or there was an enforcement issue and we take the state as a verification, is it, you know, the state that is responsible? Is it we're responsible? So I have a question there. I think in general, we want to streamline reciprocity so that we can make it easier for physicians to come here. And but we also want to ensure public safety. And so we have the issues that Amanda brought up as far as the differences in clinic hours, exams, classes. California's curriculum requirements are different. And also ensuring that, and I know that we talked about working on the CCLE exam, making sure that a different physician understands the scope of practice in California is very likely different than the full scope that they have in their state. So those are kind of off the top of my head, the concerns is, you know, how do we navigate this? Now, during the pandemic, there was, or sorry, excuse me, the VA system has already mandated licensure reciprocity. So there's a model for that. And that was done recently. There's also the concern of which falls a little bit into virtual care, like where the doctor is licensed, where the patient is. So there's just a lot to sort of consider. Ms. Walker, can you sort of give us a little bit more guidance as far as where to sort of attack this? I mean, I see different bubbles as far as the curriculum, the education part. We have the MBCE concern, and then we have the application and the streamline and the endorsement. I feel like, you know, maybe we just go down the line and address sort of one at a time to see, you know, what is feasible, what can we do. I know that Texas in medical is not going by a national board, and they are kind of taking that on themselves as the state. And then some states are saying that there's just full reciprocity if you are just licensed from an accredited school.
Right. I think one good way to start. So we have in the meeting materials the different pathways, and you can see there's a little bit of variance there. Then you've got the at the national level, basically license portability that has no board input as far as just the registration if they're moving from state to state. So it shows you the different models. For purposes of just initially starting the discussion, I'd say the first decision point is if the committee's interested at all in doing something, and it sounds like the answer to that initial question is yes, doing something to kind of address some of the redundancies that we have for a candidate through reciprocity you know, not true reciprocity when you make them do everything an initial candidate would do. So if we want to visit that, then we take the discussion in that direction. Because the question to it is, if not, and we just want to maintain the bulleted list of things they have to do to get a license in California, then you're just potentially looking at a regulation that's just going to clarify the circumstances under which you would allow somebody to skip a certain portion of, like, say, Part 4 because they were licensed before Part 4 was even existed. So we kind of need to know, just from the initial part of the discussion, is do we want to start exploring some sort of model around, like, reciprocity, where whatever those conditions may be, it helps them get to the point of being the background check and getting approved for the PCLE without showing all of their work directly from the chiropractic college. So if that's the direction we want to go, then we can kind of engage in the discussion from that point. And if the answer is no, we have our California standard of how you get a license. Then it's, if you understand, it's kind of like, then that makes it a different discussion of just how do we clarify that regulation so it's not so confusing, because it kind of purports to be a reciprocity requirement or path, but it's really not. If that makes sense, and if that initial question is clear.
Yeah, that's great. Thanks. Well, I mean, I think we need to make it easier. I think we need to make it more streamlined, and I think we need to make clear kind of the minimum requirements, and one, to protect residents of California, because different states have different, curricular standards, et cetera. I mean, yes, they're all CCE, but, we still have our standards. So, I mean, Ms. Cruz, are you in favor of, finding a more streamlined way as far as moving this forward, or just clarifying the regulations or the
No,
way?
I completely agree with you.
Okay.
Yeah, my notes initially were here to, like, I was looking for safe, I was looking for streamline, I was looking to maintain the standards we hold also in California, right? At the end, because at the end of the day, we want we want to be able to engage folks to be willing and be attracted to come and bring their practices here, but at the same time, we want to make sure it's done safely.
Yeah. So, I mean, Ms. Walker, I just, an example is, I have a colleague, she's licensed in New York, she's licensed here, but doing that was extremely challenging, and it's costly, and it does, I mentioned it, which maybe seemed a little confusing, but it does go into a little bit of virtual care, and it can feed a little into AI. I mean, people are moving around, and people live in different places. We want them to be able to come to California, and so we need to sort of, at minimum, discuss and outline, I think, the standards that we have of what's going to be acceptable, which seems to be a convoluted conversation. And then how do we streamline the application process and the verification? I mean, I'm fine with going with the state, but I don't know if there's a legality issue as far as if the information was in error and there's an enforcement issue, is there a problem with that, and sort of who's the responsible party?
Sure. We may want to start with the first question or the last question first there. And then that's why it's always great to have Sabina on the call as well.
Yeah.
But when it comes, what we'd be kind of looking at is, like, under an endorsement model, whatever you end up setting as being the qualifications, but, right now you have to have, parts 1 through 4 and the PT exams. You have to have graduated from a chiropractic college. And then we get into the very specific curriculum requirements, which chat about those in a bit, but you get to that model, and if the board's willing to accept an endorsement from another state where they're saying, yes, according to their records, they've passed NBCE, they've graduated from this college in this year, and they certify that information, staff is still going to double check and verify using their license search, because they're going to give us the verification that this person's been licensed since this date, their license is in good standing, and then basically would be, under a model, use that as the qualification plus their state and federal level background check as their gateway into the CCLE instead of all of the paperwork that we gather right now on top of that document that we get as part of the current process. So you're going to rely on that endorsement that they have a license. So that's kind of your check. As far as what happens if that verification, there was something wrong there, like if the state failed to disclose some sort of discipline, or the person never actually passed the exam. That's kind of, Sabina, if you could comment a little bit on those legal, from the legal angle, because you're relying on another state endorsement, but they are certifying their own records just like we do for other states. So if you comment on that just a little bit, then we can kind of discuss the rest of the conversation a little bit further.
Right. I mean, it's hard because obviously humans make errors when they do any of these kind of things. Like we could potentially make an error certifying for someone else. The other thing I would make sure we look at eventually, or talk about now, or eventually, would any type of specific California requirements, if this board has any specifics that we require, whether it's some certain course, like I think about another board like behavioral sciences. They have a lot of California course requirements that they really have to take into consideration about people coming from other states, suicide prevention, or different things like that. But we really need to make sure we double check to make sure you don't have any very specific California requirements that you want to make sure your licensees absolutely take. Because we are protecting the public. California is a little stricter, or the strictest of all the states probably, but we want to make sure we are just double checking on that as well. We can't, back to whether someone leaves out discipline or not. I mean, obviously we can look up on their website as well, but that there was that one in part of the law, it said pending, that there are no pending investigations into their or unprofessional conduct. That's kind of that might be a difficult one to always know, right? Because what is considered pending to one board may not be considered pending to another. Is there a complaint that's just being investigated and it hasn't proceeded somewhere formally? So I don't know if there's an answer for that either.
Yeah, thank you. And Sabina, we do have very specific courses, which is kind of where I get stuck of how we navigate it. Is we do have specific courses that are not required by CCE and are not taken by other schools. And so we've been looking at that through the curriculum package that we've been trying to do. And so we've been, saying, well, what's an equivalent of those? And so that would be a pathway, is that, they have all the other stuff. They don't have these, say, 3 classes. An equivalent is, an online course through a accredited, college, et cetera. And so they can get that work done that way. PT is not required everywhere. And the harder one on that is actually the lab hours. So we would need to define what's acceptable. Can they work in an office and get those hours? How do we verify that? There's conversation in specialty boards as far as using, they can submit videos of them doing the work, and then they're reviewed. And so then we can say, yes, they are competent in performing those techniques. So again, this kind of ties to the curriculum conversation. But again, if we are looking at access and speed, if somebody is just getting out of school and they don't have those things, they're still going to have to get an equivalent on those for them to come to California. If someone's been out of school for 20 years, they would need to get an equivalent on those. And that's, again, time. And to me, that's a barrier. So I don't know if anyone has any thoughts on how to address the conundrum of, we have specific requirements that are different than other states. How do we maintain those? And we may not be able to make it expedited.
Right, right. And that's what a lot of our other boards struggle with too, because you're trying to do the right thing, right? You're trying to do offer this reciprocity, but we do have extra stringent requirements here. You know, have we looked I think we did look at other boards. Do other boards require like 5 years of practice?
Yeah, I looked at Florida, New York, um, and we can pull it up again. I don't know
Yeah,
if we've looked at those recently, but they had outlines for
yeah.
all the different categories.
Yeah, I remember that. But, you know, I
Mhm.
mean, what if, I mean, you seem to be putting someone at disadvantage and they have to move home because somebody's dying or to take care of a family
Yeah,
member. They've only practiced a year, you know, you know, there's a lot of different situations um,
yeah.
that we should look at that barrier. I mean, that at least alone would probably help. But yeah, I
Um,
remember that. I'll have to pull up
when
those
you were
materials.
Yeah, when you were speaking, when you said someone that would have to move home, I'm wondering if that would fall into a temporary license. Miss Walker, is
We
that?
don't we don't currently have a temporary license.
No,
It's
Terry.
there's except for, well, yeah, besides it's only for
Yeah. I mean,
military spouses get one. There's this the thing about the conversation that it's a tricky conversation because it does, like you said, it intertwines with curriculum and then we have our California standards, and it's one of those things where you could look at a couple of different models of, just maintaining the standard and then helping by providing resources to how they address any deficiencies. You establish some sort of equivalent to where, at what point, if any, does experience and practice negate some or all of, certain very specific requirements. You could potentially try to explore some sort of temporary license and then, kind of get your foot in the door, and then so you can start practicing, but then you've got to make up everything within a set amount of time, because some other chiropractic boards do have some sort of temporary kind of practice allowance. The only challenge though on that is if you do a temporary license, you're saying this person's safe to practice at least temporarily for say a year, and then we say you have to go and complete all these additional requirements. How do we make the case that they were safe on day one under the temporary if they didn't have that requirement, and then why do they have to get it later? So it's kind
well,
of, there's a few different. Oh, go ahead. Sorry, I don't mean to
sorry,
speak over you.
I'll lose my thought. Um, can we do something like a probationary, like temporary probationary in the sense of notifying the public that you are from another state and you are not up to date with certain, curriculum aspects or whatever it is, that you are licensed temporarily to practice bumpty bumpty bump, but you do not have, the full chiropractic, like, and so they're notifying the public of the restrictions or the limitations as far as the education.
So BBS actually just put in something together as a temporary practice. I forgot what they call it, but it's a little bit more relevant with telehealth, right?
Yeah.
When my client moved to California and I have to continue treatment with them, and and they can apply for a certain amount of days to get permission to practice here, and there's certain things they go through, and they have a certain number of these temporary things requests they can do. I think it's within a year, but they have tackled that. BBS has, and it's modeled after psychology, but it's obviously a little easier when you're giving therapy, right, via telehealth, not so much hands-on type of practice. But they just that's one board I know that has a temporary practice. I think it's called a temporary practice allowance,
Okay.
and we
And
can look at what they did there.
Miss Cruz.
and some of the things you were saying, Dr. Daniels, it's kind of like almost equivalent to, I think of like a learner's permit, but not a learner's permit because they are licensed, they're licensed in other states, so they're not necessarily learning, but is there like, I know the direction you were talking about is almost treating like them like that they're on like how we treat folks on probation, of right where you have to inform folks or something is posted, or right, the different ways to do it, and so folks are at least informed um of the what would I felt like that's like, I know up front we were trying to the goal at the end of the day here is to make it streamlined and to, what's it called, and keep people safe and encourage folks to come and kind of practice in California. And I think I would say if that's possible without it appearing punitive in any way, right? I see that as a possibility. I would just need to like maintain the lens of, are we making this punitive in any way, right? Or appear that way.
Yeah, and I mean, it's not the intent. The intent
Yeah,
was to
yeah,
notify the public that
yeah.
they have not met all the California requirements.
Mm-hmm.
Because that is our job, is because if we say, here's the temporary license without any disclosure, we're essentially
Yeah.
saying you are exactly qualified as a licensee in California.
Mm-hmm.
And
Right.
that's not the case if they don't have dermatology or they don't have
Yeah.
PT or whatever. So
Mm-hmm. Some of the boxes aren't checked yet, but
yeah,
in
I
terms
mean,
of
so
like
probation,
baseline
yeah,
national requirement,
right. I just meant the
almost.
notification, like, can we still allow them in so they can start? And then
Mm-hmm.
we're notifying the
Mm-hmm.
public and then they meet the requirements. I mean, to me, it's either we stay with our standards or we just throw it all in the trash and we're like, yeah, anyone can come, which means that the curriculum that we have doesn't matter. Um, because if we're saying one thing for education, then we're saying something else for a licensee coming in. To me, that doesn't make any sense.
And would this be, what's it called? I imagine this for either someone trying to start their own practice out here or someone joining another person's practice. Because I know we also have for folks coming out of college, what is it called? Sceptership, something scepterships?
Preceptor.
Preceptorships. Is
Mhm.
that, so this is almost, right? It's obviously not the same thing because they have
Mhm.
graduated and they are done and they are, what's it called? Um, kind of licensed in different locations. But is that something also we'd want to consider in terms of, right? It's almost like a sponsor, like a peer endorsement of some kind if they are under. So I wasn't sure if that would be in the equation somewhere.
Okay.
That I don't think it would hurt, but I feel like that's also a way to make it less punitive as well, to say like, no, 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 I'm actively working kind of with this person over here as well, and they're familiar with me.
Hmm.
So just something I feel like could be like one of the optional checkboxes as part
Right.
of the conversation.
Ms. Fokker, is kind of what we're talking about. Is that even like a possibility or no?
I don't see why not. Especially I like your suggestion of the public disclosure portion of it because that's what, like you said, that's what separates it from just handing them a full license. Um, the pathway is kind of already there if you model it a bit after what we do with the temporary licenses for military spouses. So they get to come in and, based on us verifying that they do hold a license in another state and they're not subject to discipline, they're approved to take the law exam. We still do the background check on them. And then after they pass the law exam, they get the temporary license that's valid for up to a year or until we issue them a permanent license. And then they have that running clock of a year to wrap up all of the ins and outs of getting us the documentation that we need for full licensure, making sure they have the curriculum requirements. They're missing it, then take the course and get that documentation. So from the discussion, I'm seeing the parallels between what we're already doing with military spouses and then potentially expanding it a bit. Could be a pretty viable solution to the problem because you're still maintaining the standard, but allowing for a more expedient pathway for someone to be able to at least begin work if they can't demonstrate everything that we would need up front.
Yeah, I think that's kind of why it slipped out of my mouth. Was the temporary thing was in my head. So is that something that we can? Well, before we go, yeah, is that something that we can look into as far as a possibility and what that would look like?
Yes, yeah, we can put something together conceptually and bring it back for a more concrete discussion around it. Just kind of going down that kind of model. And we'll look at the examples that Sabina provided as well from BBS and psychology, because I think, taking a couple of different models and putting some pieces together, we can probably come up with a pretty good concept.
Okay. Also, just have in your mind what if there is no part 4? What if there is no part 4? What are we going to do with that? And then
Right. So, I'm sorry, I didn't mean to interrupt.
that's fine.
Along those lines of the concept, the way I was kind of envisioning it in my head was at least verifying that they've taken parts 1 through 4 in PT and that they have a Chiro degree, and then it would just be curriculum requirements. Are we entertaining letting them in, or I mean, if they have it, pre-part 4, it didn't exist yet. Are we looking at something else, like if there's certain states I think that don't even require part 4, or they don't require PT? Would it be acceptable to let those people begin working, or I guess that's the only piece I would need to know is where we want to draw the line for the initial qualification versus the further down the road. If we go after the model that is already in effect for the temporary license, it's you have a license in another state, so we could start there. But
yeah, I mean,
just want to clarify that.
I mean, my first thing is, I would draw the line at part 4. I'm just bringing it up because I've talked to other states and there was very, who knows, it's talk, strong conversations about not them going with their own state exam. And so I'm just saying in the future, if that is in the landscape, I think we need to be prepared on how we are going, and I don't have an answer of how we are going to address that.
Okay, sure. Yeah, we'll take that into consideration, and yeah, we definitely have enough to start putting together a concept.
Okay. Ms. Cruz, any other thoughts before I open up for public comment?
No, and I think just to clarify my understanding what you guys are talking about,
Yeah.
that the what's it called? If what we're talking about, if there is no longer, to your point, a part 1 through 4, and then exams become state specific, is that what you're talking about?
So part 4, because it's been centralized, there is conversation with states that
I'm
they
gonna make my own.
they would create their own part
Okay.
4.
Mm-hmm.
And if that was to happen, are we going to certify their exam? We have no idea. Part of the national board was that we had an understanding of what was being tested, what the standard was. If states start to drop out of that because of politics or whatever access, then we will have states that do not have part 4. And what if those people want to come to California? Do we draw the line there? How are we going to navigate that? It hasn't happened yet, but weird things happen.
Yeah. Yeah.
Does that clarify?
Yeah, thank you.
Anything to add to that, Ms. Walker?
Just noting for information that if states start doing that and developing their own state-specific exams, we're going to have to look at if you'd have to go down the path of, if you wanted to start accepting those other state exams, involving the DCA's Office of Professional Examination Services to do validations of all of those exams, just like they do for NBCE. So just putting it on the radar, that's probably costly and a significant workload if we start doing that. It's just depending on the number of states adopting. It's one more, not as big of a deal, but if you get a lot of them, it could start getting costly as well to try to validate all these other exams.
Yeah, it starts getting complicated. And like I said, I know there was a big letter from Texas State Medical Association to, I think it was the AMA, as far as them either saying that they were going to, or they are opting out of a national sort of board exam, and that they are going to withhold it in the state. So it's happening in medical. And that was just kind of the first wave of it that I got. So we just want to be aware that it is starting to happen. And so I don't know how that will unfold, and it's complicated and expensive, and how do we verify and all that. But with everything that's going on, it's a possibility. Okay. I'm going to go ahead and open it up for public comment. Moderator, can you open this up, please?
This is the moderator for members of the public on WebEx. If you would like to make a public comment on this item, you can click the raise hand icon, or audio-only participants can raise their hand by pressing *3 on their device. All right, and it appears there are no requests for public comment at this time.
Okay, great. Thank you. Any other discussion points on Agenda 5 before we move on? Hearing none. Okay, so agenda item number 6, discussion and possible recommendation regarding the use of artificial intelligence and other emerging technologies within chiropractic education and practice. And Ms. Walker, do you want to introduce it?
Just very briefly. So as the committee is aware, AI is a topic that's rapidly expanding in all sectors, obviously including chiropractic, including in government, and then specifically for the discussion today, a lot around healthcare education, clinical practice, and our regulation of the practice. A lot of expansion, and then there's a lot of different aspects and opportunities there. There's obviously the clear pros and some drawbacks or things that we have to be aware of as regulators as it relates to AI. So very broad topic, and really going to turn it over for a committee discussion just after really hitting just a few high points. One of the concerns from the board staff perspective of looking at AI, interestingly enough, it's around more so privacy for patients and their information, equity and access to the different technologies. There's concerns around the level of AI literacy and making sure that licensees know what they're doing with the new tools as they bring them into practice. There's also some concerns around how it can be used in a lot of ways to enhance practice. There's so many different models out there as far as how it's being used to enhance diagnosis, make administrative tasks easier, streamline different aspects of practice, and help spot different things that you might need to know from a patient's history, and make the ease of use much easier. Help you catch billing errors before it's submitted to insurance. Of course, insurance companies are leveraging the technology to audit records. The other concern that we're kind of seeing too is around and the potential to use AI in an unethical manner to potentially harm consumers. Just by way of example, I just used the Google Gemini tool and just asked it itself if I was unethical and I wanted to figure out how to maximize my profits, what could I do unethically in chiropractic? And it retained a number of different strategies that I could potentially use to boost my revenue and mislead consumers and get them into expensive treatment plans. So there's so much when it comes to AI in terms of your education and practice and making sure that people are competent. It's definitely a tool that more so is going to benefit the profession and benefit the users, but then there's also some areas where there's the potential for misuse, and how do we attack that as regulators? Staff recommendation on it is really just having that initial discussion, being aware, and then making sure that when we're looking at when it comes to supervision and the licensee's responsibility and level of practice, that we're holding them accountable for not only their own conduct, but the different tools that they're using, people that they're supervising, whether it be actual people or more like an AI assistant. So with that very large topic, excited to just turn it over to the committee to have a discussion.
Okay, thank you. Yeah, so the question is, why even have, I think, the conversation about AI and as far as the board? And the first answer for me is because that we govern practitioner conduct. And so for me, looking at through the lens of the physician's conduct or the chiropractor's conduct, and as Ms. Walker was talking about, we have ethical and sort of ethical guidelines, regulatory frameworks. Unfortunately, there's sort of right now there's limited evidence as far as ethical and practice implications. I mean, we all can, we see things happening and we're having a conversation, but we really don't have a lot of literature sort of on the details of the ethical problems. One of the questions with AI is who's actually responsible for the output. And so to me, the answer is obvious and it is in the literature, but who is responsible for the output? So say I am a chiropractor and I use AI and it gives me a diagnosis. I base my treatment on that. Am I responsible if something goes wrong? Is the person who developed the AI responsible? Is the state responsible? So one of the questions around AI is actually, which Ms. Walker brought up, is are our licensees who are going to be using AI, are they competent in the use of AI? So Ms. Walker, if you could write it down, I do want to have a meeting again with the schools and see what they are, if they're addressing it. I assume they are, but let's find out. Are they addressing AI competency? So we've talked about competency and untrustable professional activities and all that goes into making a chiropractor or physician. But now we have to actually talk about competencies in AI. And the board has to think about our own competency in AI. And what I mean by that is, do we understand the underlying algorithm that the particular AI used? So if do not understand the algorithm, which I will not, and there's many AI platforms. And so if each platform uses a different algorithm and we don't understand that algorithm and the doctor doesn't understand that algorithm, then we start going into questions of how it influences positively or negatively patient care, biases. Is the AI algorithm, was it developed with a cultural competency? And many are not, and some are. So for me, we have a category of if we as the board, we are looking at professional conduct in part and patient safety. So to me, it's the lens of looking at the physician's relationship to the patient. So when the doctor chooses to use AI, are they competent in the AI? To me, they are ultimately responsible for that output, right? So we have that category. And then we start falling into, when you add AI to this, you now start to have possibly a change in definition of standard of care. And we also have what constitutes the practice of medicine. So the questions for us, I think, are what constitutes the practice of chiropractic is going to be a question with AI and what we have defined as that. And then also what we define as the standard of care. Now, the standard of care can go both ways. If I have a standard of care right now, we know what that is, and that the chiropractor fails to meet that standard of care. However, if the chiropractor didn't use AI and AI has a different standard of care, and that standard of care is now accepted and considered, I'm just going to say, better, now we have the question of dealing with, is the chiropractor not following the standard of care because now the standard of care is what AI says?
Or is AI just a tool being used for a differential diagnosis? Like,
So then we get into, how is it being used for a diagnosis? Are we using it for instruction and recommendations? And that kind of was like, who's the fault? The tech developer, the physician? And DCA, the organization who mandated its use. I mean, this goes to that as well, if there is a mandate. And then we have what I talked about, the bias, the inequalities, inaccurate outcomes, disparities. So if we have a chiropractor that, say, is a solo practitioner, they don't have a lot of money and they can't afford AI, and AI starts becoming the standard of care, now we have inequality with a chiropractor that can't afford the AI and potentially below the standard of care. This gets very, very messy for me in my head.
Mhm.
So I think we need to develop policies from the point of view of the relationship, again, between the patient and the doctor, and protecting the public in that sense. And we have another big one is obviously informed consent. Now, we have informed consent, but when you start dealing with informed consent with AI, how detailed does that informed consent need to be? Meaning, is the physician then going to be required to say, I'm using a platform that is culturally competent? I'm not using a platform that is culturally competent. I verify everything that the AI recommends and says. I don't verify, and so we have the informed consent issue. We have the confidentiality and the privacy, which is, a big hot button, which Ms. Walker talked about. And then also transparent implementation, meaning that informed consent, I think, needs to include transparent implementation. And so I go to the doctor and they just rattle off really quick, oh, are you okay if the doctor uses a scribe? I'm like, sure. Well, because I'm old, I'm thinking, a little, like, I have my staff. And, then the visit starts and I forget, well, the scribe is AI.
Yeah, it's a thing. It's a thing right here on my
Yeah,
thing. Right
yeah,
there.
yeah. But so I wasn't informed, right? So, I mean, I was fine with it, but this is the thing, like, when we're doing the regulation, they're saying they informed me and they got my consent, but they didn't sit me down and explain it. Like, when I sit down and say, before I adjust somebody, you were supposed to have them sign the piece of paper, and then we're supposed to verbally, like, informed consent is not just signing a piece of paper or just saying, hey, are you okay with this? That's not informed consent, especially not in literature. Informed consent means that the consumer actually understood what you said. So that's something that we need to think about. And so what I was going back to the physician, we have to think about access for the patient, but also what is just and fair and equitable access for the chiropractor. If they can't afford a tool, how are we going to not be biased against them and they are still equitable? And then we go into that standard of care issue. And then the developers of AI in general, they are not trained or regulated to prioritize patient well-being. So, one of the questions when somebody buys that is, the practitioner, the technology that they sourced, does it have biomedical ethics? So those are my notes. Miss Cruz?
That's good. Yes, I have a fair amount of notes as well, kind of peeking through the ones that you might not have touched on
Highlighted.
yet. Yeah, let me see. Like, a lot of it honestly stems from the same places of safety and trust and performance and oversight, right? Ethics and equity. And I think you hit all the points I noted on informed consent. When it comes to performance and oversight, right, you hit on the accountability that we want to hold providers to, right? I love your description of just the responsibility of the output is still in the ether right now. I mentioned differential diagnoses and how you used it. Something that kind of came to mind and I saw in a couple of the different pieces was, is this auditable? Is this something that where you might have to go back, right? Is whatever we put in place as a standard of use or expect as a standard of use, right? Is this something that what body would then have to be responsible for auditing if we are expecting a certain way of using, right? Um, and then on top of that, you're starting to also get into the technology of whether it be the algorithm. For me, it's whether it's what knowledge base is it using, right? Um, is it using a learning out? Is it a learning tool? Like where it continues to learn, or is
Yep.
it something that just is based on a knowledge base, right? And just a body of knowledge. And is that body of knowledge, much like a lot of, I want to say, existing medical practices, um, are those based on scales and multipliers that are culturally informed, right? It's just there's a lot of ways that kind of the use of this information could do harm in some situations, but at the same time, by giving access to folks to this, used in a very responsible way and an informed way, like it could benefit so many people. Let me see here. I think a lot of the documents touched on data privacy, and I think there's just the standard of data privacy that's already out there. But at the same time, I think for me, it's going to come down to the knowledge base of the tools. What exactly are they using? Does it feed into someone's, like, if if somehow it feeds and pulls up information on this person, does it connect them to that person's profile into how well they are, what's it called? I would say, I'm trying to phrase this the right way. If it goes into a person's, say for example, someone's behind on a couple of payments, will that go into the equation somehow? Right?
Yeah.
Like, is there a way that the way a specific tool is used will ultimately end up in a patient being treated differently? Right? Because
Yep.
that might play into a back end multiplier. You don't know. So, right, a lot of these things is the more technological stuff. I don't imagine providers having to kind of audit of whatever tools they use, but it's definitely something I would say as the board, and I would say as more of the, I would say, medical community focused AI tools are being developed, kind of needs to at least keep light of. And then what does this even long-term oversight even look like? So
Yeah, I think we don't I mean, in my opinion, we shouldn't be getting into the weeds of
yeah.
regulating specific AI, which I don't think is what you're saying, but I just forgot to say that. But again, it's we're in charge of regulating the chiropractors, professional conduct, ethical,
Mhm.
and treatment. And so I guess Miss Walker, for me, and I think what I'm hearing from Jeanette as well is, the conversation as far as the board's role in this is either designing a regulation that really is specific to accountability, informed consent, ethical, blah blah blah, but not regulating what they can and can't use, because there's no way you're going to be able
Yeah.
to keep up, and it's the physician's responsibility. I think if we put the lens on AI in use between the doctor and the patient and everything that goes into that sort of bubble is, for me, where the conversation uh, should stay. I see your head nodding, but I think I see it nodding.
Yeah, no, I agree with you. When we're kind of looking at it, I mean, AI is used in a number of different manners. I mean, I've heard about 3 or 4 different regulations theoretically just kind of mentioned as part of the discussion, because you're talking about the standard of care. You're talking about their role of, taking ownership over how they're using it. Those are different regs. We're working on developing telehealth, and a lot of that language when we were discussing telehealth was around putting the onus on the provider to make sure that not only they have the consent for telehealth, but also that, their selection of, the type of technology they're going to use is appropriate for that type of visit. I'm kind of seeing something very similar with AI, where it's like you're not trying to regulate and tell them what they can and can't do with AI.
Yeah.
It's more get some solid language that's enforceable, so that we, if they misuse it, we can demonstrate and, tie it to the standard of care. Also hearing informed consent. And then the enforcement committee is working on record keeping. So if there's some aspect of, identifying, if you're using AI to automatically generate your records, you're still signing them and taking responsibility for them. But is there any necessary method of just identifying the fact that it was used to generate the record? Is it necessary or not? So it kind of, it hits a couple of different pieces, and I think it brings to light the need for the board to think about AI as you're looking at the different regulations, and if there's the need to add some sort of language within. So not necessarily like the way I'm hearing it from the committee's discussion, I'm not really seeing like a brand new regulation on the use of AI, but more integrating into our different regulations as necessary, so we have appropriate tools to protect the public.
Mhm.
Yeah, I mean, I think exactly that. I mean, it's like a tag on to informed consent. It's a tag on to record keeping.
Yeah.
It's a tag on to your diagnosis and your treatment. It's it's really a tag on to all of those things, because ultimately, for me, the physician is responsible. And so from there, it gets into the weeds. But I think we have to do something, because there's, as you saw, enough in the literature as far as regulatory boards really need to communicate, even eventually with AI developers, talk to schools as far as, what are we going to require licensees for AI competency. And so then that is falling into curriculum a little bit. So yeah, I guess I see it as not a separate regulation, but
Mhm.
clarifying, is that going to be really cumbersome? And so would that then throw it into a separate regulation? Because if we're having to clarify all of these things
Yeah.
that we've already been working on, would it be better to put it in a separate that covers it all?
Because I'm also thinking, like, what I haven't heard was billing, and then it gets into
Yeah.
marketing, and then it's right, just all these other pockets that we, where we have to respond to when there are issues related to that. And so it may hit our desks.
Yeah, but those are, good considerations. I think we'll look at it. Definitely, we've got telehealth as one of the regulation topics, like at the conceptual phase. Those two naturally fit well together, as long as you don't try to make it look too narrow. So we could explore that. Another, issue that the enforcement committee is trying to tackle when it comes to the record keeping regulation is the fact that there's the standard of care, but there's no real regulation that define, not that you would try to put an exact standard of care, but we were losing enforcement cases because we didn't have the most basic things that had to be documented in a file. So we're quasi establishing a bit of a standard of care by saying you have to have documented these things, documented it. So there's aspects that we can explore on that. I'm also seeing a parallel though too, when we're working on also the enforcement committee, that proposal that was just returned to them over the supervision of their subordinate staff, and their responsibility, the things they have to do, not being so specific. Obviously it got returned, but I think there's ways that we can kind of integrate it into those different pieces. Informed consent was another thing that was brought up. We see that frequently in enforcement, where informed consent is being misused, where it's a form in the intake paperwork and the person signs it and that's it. They're not having the conversation. They're not discussing it. They're not just documenting when it's something very specific to that patient's case that's different than, the very broad informed consent that the person signed at intake. So there's all of those different pieces. That's why I'm kind of thinking we may not need its own section, but we can integrate. But I would say maybe a lot of it would fit into the supervision requirements, the record keeping. You look at informed consent. The record keeping also covers some of the billing aspects, so we could put that in there. But I think it's a very, very good and very timely topic that I think bringing awareness to the full board so that when they're in their committees and working towards it, that they're thinking about these things. And of course, obviously, I'm helping with working on that, so I can make sure they do as well. But I think it fits into two different, but it's not something where it's like you have to go back to the drawing board and start redoing a bunch of regs. It's naturally kind of fitting into the ones that we're not even done yet at this point.
Can we also just, as you're looking at it, can we also just sort of have in the back of our mind, possibly if it was a separate regulation, just like what that would look like as far as just kind of covering all the aspects. You know, when I think of, you know, people can also be using it as the scribe, like they could look like they're the doctor's taking notes, but they may not, they could be having AI record everything, and the patient may not be informed that they're being essentially recorded, you
Yeah.
know,
But the tool
supposedly
is
word,
doing all of that,
yeah,
recording a transcript and
supposedly
a
word
summary.
for word.
Yeah.
And like I said, like I never got a piece of paper. I never said, this is what a scribe is. This is what it's recording, da, 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 you know, sign here. It was like, you okay with a scribe? Sure. Okay. Which I don't know. I think when you're dealing with patient records and patient confidentiality, I absolutely think the patient should be fully transparently informed that whatever they're saying is being recorded or whatever. So I don't know. Let's just hold open, maybe having a separate reg that would cover everything in general. Um, if we could do that, and then also look at how we feed it in.
Certainly, yeah, we can look at it definitely both ways. I think, you know, starting with making the list as far as if it was like a separate reg in itself, because you're, like you talked about earlier during the discussion, you're establishing a standard. And I'm seeing a lot of the parallel to the way we had the discussion when it came to telehealth, of making sure that, you know, you're familiar with the tool that you're using, that's appropriate for the scenarios, that you're getting that true informed consent, which you can spell out later what it means. So yeah, we can develop it definitely either way. It's just going to be a matter of really making sure we've kind of established some of those standards, and we need to be your favorite term, broadly specific, so that we don't pigeonhole ourselves as AI is going to continually evolve over time. We don't want to be chasing something.
Well, that's why I think
so
the broadly specific, I think, applies if we just focus on AI in relation to the doctor and the patient. And just like we do with, you know, without AI, the informed consent, ethical behavior, standard of care, appropriate care, right? Those are the things that I think we need to keep that lens on. And then I think we'll be
Fair.
broadly specific, because then it holds the patient safety and the patient in the center of the wheel, with the doctor being responsible. It holds those two, for me at least, very tightly, and then everything else is kind of on the outside.
No, I appreciate you framing it that way, because that really focuses all of this within the scope of kind of, I would say, our control, the provider's control, right? Just these are things that are actually actionable.
Yeah.
Mhm.
And that's what our role is, not like you can use this or you can't use this,
Yeah.
so to speak, as far as which AI tool, I think. Yeah, I mean, a lot of my notes kind of started blurring together with telehealth and AI, because there's definitely, and the new word is virtual care. I mean, that's in the literature. So just, it's moved from telehealth to virtual care, I think, is the language now.
Well, I think,
great.
yeah,
Okay,
with
cool. So we'll
the
make sure
broadness of all the industries going there. Yeah.
Yeah. Okay. Let me just see if I had anything else. All right. Any other comments before we open it up for public comment?
Just one
Yeah.
one potential wrinkle in the discussion on AI, and it's, you know, I don't know that it has a lot of support at the federal level, so it might get amended out of the current bill, but HR 1 does have a 10-year moratorium on states enforcing AI. So that's another part of the consideration. So the contingency plan on that is if it did pass as written, and then it would kind of filter down to kind of restricting our ability to regulate in the realm of AI. We can establish something along the lines of guidelines where it's just guidance, but you can't actually enforce it. So at least we can help inform licensees. But that was the only other kind of bit of a wrinkle that's going on that we're just monitoring is the bill at the federal level that would take away a lot of the states' say in the regulation of AI. But I know at the federal level, there's on both sides of the aisle, there's concerns with that specific provision, so it potentially could get amended out of that bill. So that was the other side.
Can you explain that
on it.
more in the sense of like the conversation if we're having the conversation of regulation with AI, but it's in relation to that doctor-patient relationship, informed consent and stuff, how does what you're saying apply to our ability to still monitor physicians' conduct, etc.?
We would be fine for monitoring. Likely, we'd have to do like a true legal analysis after the bill, if the bill passed as written. It's very broad. So what does that mean, and how does it translate down to the state level? We should be fine in that we take the same approach that we do on a lot of things where we're regulating licensee conduct, where the conversation didn't go there today. So I don't think we would have any hiccups, but where we would start to encounter problems would be more along the lines of if we started looking at something where somebody has to give us the key to how that specific tool was using, where we were implementing some kind of new requirement that would somehow put some sort of burden on an actual AI software to have to meet certain requirements, we would probably start having issues. As long as we're focused on the content and the use, and we're not starting to specify that all records have to be able to do a specific thing to where they'd have to change AI, that's where we would have potential problems. But I just wanted to just throw it out as awareness, because that's another contingency in the realm of that AI discussion.
Yeah, I mean, I think that's where, like, for me, I go to my head, like the algorithm. There's no way we're going to understand or know what algorithm they actually used. We know there's the black box and the learning, and but yeah, so it's not to get into the weeds of that, but I understand what you're saying. Thank you.
Sure.
Okay, moderator, can you open it up for public comment, please? Agenda item number 6.
This is the moderator for members of the public on WebEx. If you would like to make a public comment on this item, you can click the raise hand icon. Or if you're an audio only participant, you can raise your hand by pressing *3 on your device. All right, and it appears there are no requests for public comment.
Okay, great. Thank you. So item number 7, future agenda items. I had just continuing these conversations, but virtual care. And then also, ironically, on my list was I really want to move up the definition of practice and get that on the agenda as far as the satellite certificates, also regarding the public comment, which we've had multiple conversations about, and we've been talking about how to deal with that movement of physicians and keeping the public informed. So those were my only two to make sure those are on the agenda. Ms. Cruz?
No, yeah, you hit the one I was like going to bring up the satellite and pocket license conversation.
Okay. Moderator, can you open this up for public comment?
This is the moderator for members of the public on WebEx. If you would like to make a public comment on this item, please click the raise hand icon, or if you're an audio only participant, you can raise your hand by pressing *3 on your device. All right, and it appears there are no requests for public comment at this time.
Okay, great. Thank you. All righty. Anything else before we adjourn? No? Hearing none. Okay. All right. Well, thanks everybody. So we're adjourning the meeting. It's 2:04.